Professor Blumstein told me to use the 3 B's of public speaking. That is, be simple, be brief, and be gone. And I promise you I'll do that. They asked me to talk a little bit about the Attorney General's perspective on the health care debate. And to do that, I got to give you a little bit of background about how the attorneys general, in, not only in Tennessee, but the other 56 states and territories work. The National Association of Attorneys General consists of 50 state attorneys general and the 6 territory attorneys general. And they're roughly comprised of 40% Republican and 60% Democrat. Of the 50 states, 43 attorneys general are elected by some type of popular election. The rest are either appointed by the governor or appointed by a joint convention of the legislature, like in Maine, or some type of permutation or combination of that. In some cases, they're appointed by the governor and confirmed by a bicameral legislature. Tennessee is the only state where the Attorney General is selected by the Supreme Court of the state for an 8-year term, and after he or she takes the oath of office, that person is a constitutional officer who has an 8-year term and can only be removed by impeachment or by other removal statutory procedures or death or resignation. Probably Tennessee, and I can say this now since I'm no longer in that office, has the most independent Attorney General of any state because he or she really heads the 4th branch of government. They are, the Attorney General of Tennessee represents all 3 branches of government in some shape, form, or fashion, but he or she doesn't fit into any 3 of them actually. But it is a very independent office, and because it's not, quote, politically elected, it can be independent. Now, several things come to mind in the discussion, and I don't want to be duplicative, but since I read the entire bills, of course, out of the entire bills and all of the comments from the entire bills, 5,000 or so pages, I came up with a few observations like arbitrary legislation, citing the case of the U.S. Supreme Court case of Helvering versus Davis, which said basically that Congress does not possess the right under the spending power to, quote, arbitrarily display power, end quote. Also came out with a nugget when I read those 5,000 or so pages that talked about fundamental fairness, that there's no legitimate national interest in the mandate, the Medicaid mandate, as well as the Cornhusker Compromise, that as to the Cornhusker Compromise or the Nebraska Compromise, it is a pure political payoff. And also, I came across the equal sovereignty argument, the due process argument, and also Article 1, Section 8 of the Constitution, which says clearly that Congress may spend federal taxpayer dollars only to, quote, provide for the common defense and general welfare of the United States. Now, I totally agree with the professor, with Todd and Bill, that this is a living tax. That is, the mandate's a living tax. It more likely than not contravenes the enumerated powers in the 10th Amendment. And also, in my reading of the 5,000 pages, it reminded me of when I was in a similar class, not nearly a class of esteem like Professor Blumstein, but I remembered that there are 3 basic categories involving the Commerce Clause, if I recall correctly. One is it's got to be, one category is it's got to concern a channel of commerce, and number 2, it's got to concern some type of instrumentality of commerce, and number 3, it's got to affect some kind of economic effect on commerce. And I don't think that a non-activity, that is just living and breathing, fits into any of those categories. And neither did 15 of my former colleagues in the National Association of Attorneys General, because of those 15, 2 being Democrats, 1 from the state of Oklahoma, Drew Edmondson, and the Attorney General of American Samoa, Democrat, and 13 Republicans wrote letters to the senators and some representatives basically mentioning all of these constitutional infirm arguments. After the AGs wrote the letter, and I'm not going to say that that was the condition precedent to his pivot. We've been talking a lot about pivots here lately, or possible pivots, but the pivot of Senator Nelson from Nebraska, he apparently capitulated and said that, you know, if the bill comes back in a compromise or a conference or some type of resolution, I want to withdraw the Cornhusker compromise. Now, it begs the question then that why do attorneys general do what they do, particularly on legislation that hasn't even passed yet? Well, obviously, you don't, a case that had a situation which hadn't become a law signed by the president is not a ripe case to file a declaratory judgment action in federal court or another court. You can't actually file a lawsuit. Professor Blumstein may challenge me on that and say, well, you might be able to. I don't know how to. But what they did in writing those letters is they said, if you do pass this law, or something like this law, we are going to challenge it and litigation will ensue. And so don't waste more tax dollars in passing a law that you know is unconstitutional. Very similar to what the Attorney General at the state level does when senators and representatives ask him for an Attorney General's opinion or her for an Attorney General's opinion, and that Attorney General says, this law that you have proposed, in my view, is unconstitutional, so don't pass it. And so I think it showed courage on both behalf of Republicans and a couple of Democrats to write those letters to the congressmen, to write those letters to the senators, and to say, look, federalism, sovereignty, the 10th Amendment, due process, the Commerce Clause, there are too many holes in this ship. It's going to sink if you pass it, and don't waste more tax dollars in defending an unconstitutional lawsuit. I'll be happy to entertain any questions that you might have, and consistent with my 3 Bs of public speaking, I yield the floor.